call the meeting of this November 25th, 2025 Board of Zoning Appeals meeting to order. Would you please call the roll?
Mr. Creech,
Here.
Mr. Desgeorge,
Here.
Mr. Wyatt,
Here.
Mr. Cheffin,
Here.
Mr. Russo.
Present. Okay, second item on the agenda is approval of the September 23rd, 25 minutes of the regular meeting. You have them in your packet. You've had a chance to review them. Any modifications, any changes, any questions, comments? Hearing none, can I have a motion to approve the minutes?
So moved.
It's been moved.
Second that. I don't
Steve, been moved by Steve. Moved by Steve, seconded by Matt. All in favor indicate by saying aye.
Aye.
Opposed, abstentions, minutes have been passed. Okay, for old business, we have BZA 2025-03, 36 East High Street Administrative Appeal. Move right into the evidentiary hearing. All parties who are gonna offer testimony or evidence, could you please come to the front? I'll have counsel swear you in now.
Raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Let the record also show that we have Colleen Wimmel from Wimmel Reporting Service here as a court reporter, recording the proceedings, I guess at the request of the top. Okay, old business, let's, Zach, would you like to
Yes, I'll be happy to.
make your presentation?
Evening, board members. Okay, so our case this evening, as the chair mentioned, this is an administrative appeal. The location of the appeal is 36 East High Street here in Oxford. This is case number BZA 2025-03. This had been slated for an original hearing date on September 23rd, and at the appellant's request, we postponed that to tonight's meeting, November 25th. Here are some basic details about the appeal. So the appellant is Wiseman Enterprises Holdings, Inc., and the attorney for the appellant, who is here this evening, is Jack Grove. The property owner is 36 East High Street LLC, under care of Benji Fetterbush. The current use of the property, it's a music/entertainment venue. And the proposal at hand is to replace two existing manual changeable copy signs on an existing marquee out front with two LED message displays. And the staff decision in this case, the decision of the zoning administrator, so I made a decision as acting as the zoning administrator to deny a submitted sign permit. That was number P 2025-0320-0320. And this decision was rendered on July 9th, 2025. And so that is the decision that is being appealed. And then here's just a very basic location map showing the subject property highlighted in black outline. So this is at the northwest corner of North Poplar Street and East High Street, which of course is US 27. And then this next view just shows you the zoning classifications in the area. It's all zoned the same zoning district. This is in the UP Uptown zoning district, and is also in the Uptown Historic Overlay District. So a little bit later, I will highlight the fact that this particular request to replace the manual changeable copy with LED display, it has already garnered approval from the Historic and Architectural Preservation Commission of Oxford. The certificate of appropriateness has been approved and has been effectively issued for this request. So at this point, the only thing kind of standing in the way of a full zoning approval of a sign permit would be the matter that is pending before the board this evening. Okay, so I thought I would start out with a little bit of site history. This is, of course, a very unique structure here in Oxford. The Smith Library of Regional History had noted it as an Art Deco. I believe there's maybe an argument to be made that it's an art moderne instead of an art deco, but in any case, it's certainly a very unique structure here in Oxford. Originally opened in 1938 as the Miami Western Theater, so here's a little snippet, an announcement for the gala opening. But the theater closed in 1988. The property was then later purchased in 1993 and was converted into a restaurant called First Run. And the name later changed to Brick Street in 2004, which of course it remains to this day. Okay, so I thought I would start out here, walk you through the sign permit history applicable to Brick Street. So I'm going to take you all the way back to 2013. There were a couple of sign copy changes that took place with respect to the two cabinet signs on either end of the marquee. So of course the marquee is right here that has the two yellowish portions, so those are the changeable copy portions. There is this sign in the middle. I'll call it a neon sign. I don't know if it's technically neon, but I think many would identify it as a neon sign that spells out food, music, fun. So this sign permit was issued to Clusty Signs for cabinet sign replacements ×2, again, either side of the marquee. And this was certainly acceptable under the zoning. Sign copy changes are allowed even for non-conforming signs. So the permit was able to be issued and the sign replacement effectively passed a final zoning inspection. Then moving ahead in time to 2022, so Clusty Signs applied for a sign permit. So this was a very similar permit to the one that is now at hand in 2025. This was to replace those two manual changeable copy signs on either end of the marquee with electronic LED displays. There is a copy of that denial letter in your packet. It's included in the pertinent documents. So a pretty similar outcome here in terms of the decision. The zoning was denied. The proposal was considered a replacement and not maintenance or copy change. Therefore, the permit was not approved and the project ultimately did not move forward at that time. What was proposed at this time was a Watchfire board, a 10mm W series full color display. Originally, my thinking was with the 10mm, I thought that maybe referred to the thickness of the screen itself, but it actually has to do with the pixel resolution. And now here we are in 2025, so the permit at hand that is now being effectively appealed with the administrative appeal request. So this is, it was Wiseman Enterprises Holdings that applied for a sign permit for replacement of the manual changeable copy signs, again with electronic LED displays. Pretty similar sort of product. Again, it's a Watchfire product. It is a 6mm now as opposed to a 10, so it's higher resolution. The claim that was presented in the documentation with that permit was that the work would qualify as maintenance of a non-conforming sign and should therefore be approved. In this case, it had been the same sign designer, Clusty Signs, had prepared the plans. And you might also take note, just kind of flipping back and forth here, the nature of how the plans had been prepared. So the sample image, if you will, has changed. So you've got this karaoke night, Monday night example from the 2022 permit. Moving ahead to 2025, looks like there's at least an attempt to try to imitate or mimic the existing aesthetic character that is already present with the manual changeable copy. But nevertheless, the zoning decision was more or less the same as it was in 2022. The project is still considered replacement and not maintenance. That is the zoning administrator's interpretation. That's the interpretation that is being appealed. Okay, and as I mentioned, the HAPC, they have already approved a certificate of appropriateness for the two new electronic message boards, and they approved it subject to 4 conditions, those being static signage, no scrolling marquee, no moving images, illumination adjustment that would be recommended by the installer to reduce distraction, and attempted adherence to traditional character. Okay. And these are just some images. I just Googled the product, Watchfire 6mm. These are images that they had.
Use of non-representative structures and ask that they be excluded.
This is an administrative hearing, is the
Yeah.
presiding officer, you have the
Well-
discretion.
We'll let Zach finish his
Okay.
presentation.
Well, I would say that probably the closest example would be the movie theater. So certainly, these are just showing different situations where you can have electronic message boards incorporated into permanent signage. So you've got a canopy here as an example. You've got, of course, a marquee here as an example. I live in Miamisburg. There is a movie theater downtown, the Plaza Theater, that has an example of a sign much like this, electronic LED display that is part of their marquee. So again, electronic message board, I'm going to refer to that as EMB for short. LED stands for light emitting diode. That is the type of technology for the display. So and as a reminder, it's a full color display. The zoning code doesn't regulate color in any way, so you shouldn't have to give consideration to that. And then the signs themselves are remotely managed. It's through a cloud-based platform called Ignite OPX. So essentially, as I understand it, if I understand it correctly, it's you pull out your mobile device and you can effectively program or reprogram the sign as may be needed.
Question, I'm sure we'll get
Yes.
to it. Bring that slide back up. Are those, what you're showing there, are those in any way representative of what what was proposed in the original, or the second request for the upgrade? Go back to that previous slide. Yeah, that one.
So these are the plans that were actually submitted,
Right.
but as I understand it, it's as simple as reprogramming the screen. So there are conditions that talk about attempted adherence to traditional character, no moving images, et cetera. So the hope would be that, if this were allowed to be installed, that the property owner or the business owner would be able to adhere to those restrictions.
Those graphics were submitted by the applicant.
Correct.
Okay,
Yes, these images I just pulled off of the website.
gotcha.
Okay,
But an earlier version had that karaoke night thing, right?
correct.
Okay.
The 2022.
The
Yeah.
2022 plans had color represented, a greater degree of color.
Right.
Okay.
And a different pixel resolution, correct?
Let's
Jack, you
let
gotta wait.
Zach finish.
Well, they're
We'll let Zach
presenting.
finish.
Okay, so the next part of the presentation focuses on the non-conforming aspects of the present signage, just to make sure we're all on the same page in terms of how we view these particular signs at hand with respect to the Brook Street business. So the answer is yes, they are non-conforming, but why? So we have a total of 5 wall signs. So of course we have the 2 cabinet signs, we have the 2 marquee signs, and we have the neon sign in the middle. The zoning code normally only permits 1 wall sign per tenant, and the section is referenced there on slide 13. Also, only indirect illumination is permitted. This is considered a form of direct illumination. Direct illumination is not allowed, and the section number is noted on the slide. And then based on the submitted plans from the applicant, the marquee cabinets themselves are shown to be just slightly above the maximum height restriction for wall signage. It's 3 feet maximum for any new wall sign, and because they're 3 feet 5 inches high, technically they also exceed the 3-foot maximum height limit. Okay, and then I thought it would be useful for us to review the illumination definitions straight out of our zoning code. So this is out of section 1151.07. There are 3. The first one is direct illumination. So this is a source of illumination that is enclosed entirely within a sign and not directly visible from outside of the sign. Then we have indirect illumination, which is a source of illumination directed toward a sign so that a beam of light falls on the exterior surface of the sign. So an example here in town would be Chipotle. And there are many other signs with this exact form of illumination method in the Uptown District. They're quite common. Natural illumination is the last one. This is just simply illumination that's provided only by the sun, moon, and other broad environmental sources such as street lights, parking lot lights, building lights, not provided with direct or indirect illumination. So an example of that in town would be the Ceriso Asteria Bar awning that is over top of the storefront. There's some additional signage regulations that are applicable universally across all zoning districts. Section 1151.03D5 states the following. The following signs are specifically prohibited: moving signs, flashing or animated signs, balloons, gas or other inflated signs, portable signs, searchlights, streamers, spinners, pennants, flags. So in having an LED display board, there is perhaps a greater risk that the programming of such board could result in flashing or animation, which is not a permitted form of signage under the Oxford zoning code. There is another stipulation in 1151.03B that states no signs are permitted other than those specifically permitted in this code. And the way that I would translate this in just kind of my own professional terms is that the sign code is considered prescriptive. So if a sign type is not specifically or expressly provided for in the text of the chapter, then it is a prohibited sign type. So the zoning code does define what a changeable copy sign is, but it does not expressly allow for this type of sign in any zoning district. However, there is an exception to that. So in the zoning code, in section 1151.05E3, it states that a publicly available fuel dispensing station may use a 12 square foot area of no more than one permitted wall or freestanding sign for changeable copy to display the price of fuel. And this can be applied on both sides of a two-sided sign. Now, this is problematic because when it talks about displaying the price of fuel, that is a content-based restriction, and that is not something that the city is able to enforce at this moment. But everything else, if you consider that, if you detach that part from the rest of this sentence here, everything else is very much enforceable, because you can have signage restrictions based on land use, based on location. So when it refers to fuel dispensing stations, that is referring to the land use. It's irrespective of the content. This was alluded to in the staff report, where I mentioned that if a gas station wanted to display the price of cigarettes, for instance, in addition to, or perhaps maybe in lieu of fuel, I think that would be foolish to do so, but technically they could, that would be content that, at least looking at the code literally, it shouldn't be allowed. But absolutely, if I was confronted with a permit of that nature, I would not be denying it based on the content. So it's definitely true that the sign code is in sore need of an update to reflect all of the latest case law, in particular the Reed versus Gilbert case, the US Supreme Court 2015. We absolutely need to rethink some of the terminology that the sign code presently uses. So that is something I'm always cognizant of whenever I'm getting a sign permit across my desk. Okay, so I wanted to hit on changeable copy sign, the specific definition. And this is out of section 1151.07E. So the zoning code defines a changeable copy sign as a sign or portion thereof with characters, letters, or illustrations that can be changed or rearranged by mechanical, electric, or manual means. So we don't really have any precedent in Oxford in terms of electric or electronic changeable copy, apart from the gas station pricing, like I already mentioned. So the example of manual changeable copy here would be the DQ, the Dairy Queen out on College Corner Pike. So they were permitted to have a changeable copy sign that was accommodated through a conditional use minor amendment request, which is a discretionary review procedure. So we were able to consider, in effect, a waiver to the zoning code in order to grant a changeable copy for a land use that is not a gas station. The electric changeable copy example, this is a city where I used to live. This is the city of Trenton, that is 25 minutes due east of Oxford. For their city building, they have electric changeable copy outside of their building, so it will change the copy. I don't know how many seconds every time it updates, but it looks like the example here, it's advertising Parks Board meeting. I've seen Planning Commission meetings advertised. I've seen the temperature outside advertised. So you can essentially program it to display whatever content you wish. Okay, I wanted to also mention some precedent with respect to electronic changeable copy. For this, I'm going to take you back even further than 2013. I'm going to take you all the way back to 2010. City planner Catherine Dale was in charge and serving as zoning administrator at the time. So in this case, prior to this case, as I understand it, just from reading the staff report, is that all gas stations up to this point had had manual changeable copy. So anytime they needed to change the price of fuel on their sign, they had to manually put the letters up. So there was an application that was submitted by Circle K Marathon. So this would have been at 327 West Spring, where the Brick Street Cafe is situated presently. And just taking from Ms. Dale's staff report, so she states that Section 1151.05E3 states that fuel stations are permitted to display fuel prices with a changeable copy sign. A changeable copy sign is defined as a sign consisting of characters, letters, or illustrations that can be changed by mechanical, electronic, or manual means. However, and these are her words, however, the definition still does not address the specific electronic format, nor does it address LED. Furthermore, she states the code states that moving signs, flashing signs, and animated signs are specifically prohibited. In order for a sign to move, flash, or be animated, it would have to be electronic. Ultimately, what happened, the board decided this variance case on March 17th of 2010. It was a vote of 3-0 to grant the variance. Now, this was a variance, so technically, it should have been only specific to this property and not any other property. But having come on board in 2019, the direction that I was given was that essentially this case should be treated as precedent setting and almost, in essence, providing clarification on how the code should be interpreted and applied, such that if we were to receive any future gas station permit that had electronic display for fuel pricing, well, predominantly be fuel pricing. Obviously, like I stated, we wouldn't observe content now post 2015 in the Reed versus Gilbert decision. This would have predated that. Essentially, the direction that I have been given and I've kind of adopted as my own stance, just based on that direction, is to simply approve these as compliant. So we're not forcing every gas station to go for a variance just to have digital numbers for their gas station, for their fuel pricing. Okay, so moving into the non-conforming sign section, this is in 1137.10. So 1137.10A1, this is all about the determination of a legal nonconformity. It reads, an existing sign that does not conform to the specific provisions of this code may be eligible for the designation of a legal nonconforming sign, provided that the sign was created by a valid permit or variance or complies with all applicable laws on the effective date of this code and amendments thereto. So in this case, certainly Brick Street, it's all recognized as legal nonconforming, the 5 signs that they have. All signs are legal nonconforming. The next section talks about the loss of this status. It states that a legal nonconforming sign loses this designation if, and there's several options here essentially. The first one is if the sign is relocated, it loses its nonconforming status. At that point, it has to conform to the present regulations. Same is true with number 2, if the sign is replaced. So ultimately, that's where I landed as a zoning administrator. I landed on this sign, this manual changeable copy sign, well, in duplicate, ×2, either side of the marquee, is effectively being replaced. Because of that, it was my determination that the non-conforming legal status would be lost by replacing the manual changeable copy with LED boards. That was my interpretation, but certainly there are due process rights that are available to any applicant, and they can bring forth an appeal to this board, and this board has the power to override my decision, and thereby you're assuming the same powers as the office, my office as zoning administrator, in the decision that was rendered in this case. Number 3, the option there, the structure or size of the sign is altered in any way except towards compliance with this chapter. And the key aspect here, and I think this is probably true to the appellant's argument, at least in particular to the materials that were submitted with the permit, they were arguing that this is considered general maintenance. Changeable marquees, I think when it states that, it talks about like changing the copy on a marquee does not, you don't lose your non-conforming status just because you change the message on the sign. Facing copy changes, so those would be like the cabinet signs that I mentioned earlier, the 2013 permits. So the appellant in their appeal believes the request should be allowed pursuant to this subsection 3. However, again, staff believes the request falls under 2 and not 3. And the last 2 are not really relevant. It's if the sign is part of an establishment that discontinues its operation for a period of 1 year, or if the sign has not been used for a period of 6 months, non-conforming status could also be lost. So we have additional guidance provided in 1137.10c about allowable maintenance and repair of non-conforming signs. So the code states that normal maintenance shall be permitted, and it provides some examples. It helps to kind of clarify it so that there's some guidance. It includes painting of chipped or faded signs, replacement of faded or damaged surface panels, or repair or replacement of electrical wiring or electrical devices. It further states a non-conforming sign shall not be structurally altered to prolong the life of the sign. So this was the section that was cited in the zoning denial letter, since the cover letter submitted with the application cited it as justification. And again, I think I've already hit on this. The appellant is appealing staff's interpretation. The proposed work, my interpretation that the proposed work is beyond the scope of this provision. And then just as a general reminder too, section 1127.01, interpretation of provisions. In the interpretation and application of the provisions of the zoning ordinance, these are held as minimum requirements adopted for the promotion of the public health, safety, and general welfare. The zoning administrator shall interpret the zoning code. So what I want to mention with respect to this section, so the proposed work, although being done to existing non-conforming signs, again, my belief is it does not qualify as normal maintenance. And I've listed out, again, the literal text that's taken from the code. But then I was faced with having to apply and interpret this provision with respect to the permit details that I was providing. So I always try to offer some guidance to my applicants whenever something is being denied. I try to explain why, rather than just saying it's simply denied and citing a section number. Existing electrical devices, obviously I'm no expert when it comes to signage or the sign industry or electronics or electrical connections, so I tried to phrase this in the best terminology that I could at the time that I wrote the letter on July 9th. Existing electrical devices are limited to illuminating bulbs within the interior of the cabinets and do not include electronic message boards, EMBs. And the way that I phrase this is, in other words, the existing cabinets may be refurbished if components are replaced like for like. I think, in essence, what I was trying to communicate is, as long as you're maintaining essentially the same exact thing, which is a manual changeable copy sign, maintenance is absolutely permitted. It's not only permitted, but the code actually requires that signage be maintained in good working fashion, be repaired if it becomes damaged, etc. So if it involved, replacing electrical equipment, if the equipment might have been slightly different than what had been in there, I don't think I would deny it simply because it's like for like everything has to be exactly swapped out the same way. Like for like means to me exactly what is not being proposed by taking this manual changeable copy sign down, replacing it with LED EMBs. So I will end with a summary. So the existing marquee cabinets are non-conforming because they contribute to the number of signs being more than one permitted wall sign. They exceed 3 feet in height. They use direct illumination. Replacement of the marquee cabinets with EMBs does not qualify as normal permitted maintenance. The replacement results in the loss of the legal nonconformity. Examples provided in the code as normal maintenance generally convey this idea of replacing like for like replacing faded or damaged panels, replacement of wiring or devices, not upgrading the technology. And then I would just clarify too, the reason we're focusing so much on these non-conforming sections is because the situation involves non-conforming signs. If we were talking about a conforming sign that was being replaced with an LED, the answer ultimately would still be, it would be a denial because the zoning code does not allow for direct illumination, and based on precedent and guidance in terms of the code language, LED is restricted just for fueling stations. So even if the proposal involved replacing one conforming sign, an EMB would not be allowed by right. So I'll lay out the choices for the board, and there's two actions you could take with respect to my decision and my interpretation. So the first course of action that you could take would be to affirm the staff interpretation. So what this would mean is the proposed sign upgrade would not be permitted by right. Components to the existing manual changeable copy sign, like wiring, bulbs, panels, etc., could be replaced without issue. And also, this is an appeal, not a variance. So variances could still be sought for the illumination method, the sign type. We have had variances for direct illumination already in the Uptown. We've had them, I'm aware of at least two, for Starbucks and Dobies. Those are a little bit different than, they're certainly not LED boards, but with Starbucks it's like a halo glow around the logo. And I think with Dobies they've got the lettering and they've got the halo that glows around it. So those are considered direct illumination. The existing manual changeable copy is direct illumination because the light is internal to the cabinet, essentially, the sign. I think the more common terms in the industry are actually internal illumination and external. Our code uses the terms direct and indirect. But in any case, variances could be sought for illumination method. That is still very much a remedy that is available. Reversing the staff interpretation would mean the sign upgrade would be permitted despite the non-conforming status. This new interpretation would need to be applied equally to all future applicants. So this is precedent setting. This is the board saying, actually, based on how the code is written today, this is how it should be applied when there are similar facts, a similarly situated property or application. So therefore, any owner that was possessing a directly illuminated changeable copy sign could upgrade at that point, in theory, to an EMB. I think if it got to that point, and I'm aware of this, I think there is there's a desire to perhaps put a moratorium on this style of signage in December, to take that to council. So if the board were to decide to overturn my decision, which I won't take it personally if you do, just want to make that clear, then there is still, there is a backstop whereby we can we can start to have that conversation as a community about, okay, obviously the technology has changed since this sign code was originally written. There's a lot of new case law to consider. So it very much is in dire need of amendments, and that legislative process can happen. And I think a moratorium would allow for that. But of course, the board owes a decision to the appellant who has submitted this application. It's before you. They're owed a decision now, despite the fact that this legislative stuff just hasn't got going yet. But certainly can in the future. Once any EMB is installed, the risk of violation would increase, as programming for the sign could easily result in flashing or animation. And actually, so I don't think I realized this when I wrote the letter in July, but I now know that there is actually a definition in our code for a flashing sign that talks about a 2-hour interval. So it actually regulates in a sense, I suppose you would combine that in conjunction with the standard that talks about no flashing or animated signage. Essentially, the definition is if you're going to be changing the copy more often or at a lesser interval than 2 hours, then that is effectively considered flashing and is prohibited. So there would be some code support there that would help to prevent sort of the behavior that is, I think, expressly provided in the code is it's negative. It's not something that we want to see. It's not good in terms of traffic safety and a variety of other governmental purposes that you might attach to it. But I just feel the need to just mention that it could be as easy as flipping a light switch, as easy as reprogramming the sign, and you've got animation or you've got a change in the copy that is of a lesser interval than the 2 hours. So that is a risk, and of course that would be a violation at that point, but it would take enforcement action to follow up. So I think it would be fairly difficult to enforce, because if we say, oh, you got to change it back, and they change it back, well, then they can just change it right back. So it's one of those things where it just could go back and forth. And so I think that's why it really deserves the attention as a legislative, decision or legislative discussion. Obviously, that's not the board's purview. The board is their purview is to act in a quasi-judicial fashion. But yes, nevertheless, I wanted to mention that as well. So that is all I have to share with you. I'm happy to take any questions.
Thank you.
Thank
Any
you.
questions from commissioners?
Well, Zach, you've given us a lot here, quite a bit to digest.
I'm sure there's more to come.
Well, I suspect so. The section that you cited in your letter of July 9th, where you denied the application, 113710C, the last sentence it says, a non-conforming sign shall not be structurally altered to prolong the life of the sign. And I think you cited that. I don't know that you used that language in there, but under your understanding, what they're proposing, is this a structural alteration?
To me, the structure is the marquee itself, but I think the spirit of that provision is stating that there should not be, this gets into the notion of repair versus replacement. So I think the only thing we have as a given at this point is the code says that replacement is definitely loses its non-conforming status. Repair, on the other hand, you could still do and not lose the non-conforming status. So where you draw the line between the two is more of a gray area, and that's where the interpretation comes in. So I think it would be prudent, to ask those types of questions. I think that's a good question to ask, is this prolonging the life of the sign to such an extent that it should maybe just comply with the current provisions of the code?
Well, doesn't it seem pretty clear that that's what the applicant wants, to prolong the life of the sign? They're saying they can't, it's not workable now because they can't get the pieces or whatever, and they need to do this to prolong the life of the sign. Isn't that?
I think that's the general intent. I don't want to mischaracterize
Okay. But
what
I'm asking you
the
what
goal is.
from
But
your understanding of what they want. Is that fair?
yes,
now?
I think that's fair. Yes.
But the other question I have is about this section that dealt with the electronic signs with the gas stations.
Yes.
Can't remember it right now. Not my head. Oh, here it's on page 244 of the code. And was that put in just specifically to deal with that application back in 2005 or whatever it was? Was that
So,
put in after that, or was that already there?
my read is actually the language has not changed
Since when?
since 2010 in the BZA case. Because if we go back, I'll go back to the slide actually about the Circle K and Marathon precedent. This is slide 19. So this is where City Planner Catherine Dale was essentially reciting the code language, and the code language it mirrors what's in the present code. So I think that language has always been there. It's always said changeable copy is, well, I shouldn't say always. I mean, there was a 2003 overall a code overhaul that took place in 2003. So that's probably when the language was introduced into the code. But the definition at that time stated changeable copy is manual means, it's mechanical means, or electronic means. But in the staff report, Ms. Dale is stating, even though it says electronic, the code doesn't deal with LED. She still felt like it needed a variance, like she couldn't just approve it administratively. The code support wasn't there. And through the action of the BZA, that set the precedent that said, actually, no, we're gonna interpret it this way. We're gonna say electronic changeable copy with respect to fuel stations means you can have LED numbers for fuel
Would you
fuel
interpret
pricing.
that decision to actually change the code then?
I'm sorry, can you repeat the question?
By that decision by the administrator back in 2010, would you agree that that changed the code?
It changes how the code is interpreted and applied. And that interpretation has stood since then.
I believe you said entering in, it was your understanding that the code, that the decision rendered here was to be enforced and applied going forward with respect to fuel stations, but that the code itself had not since been updated.
The wording of the code has not changed with respect to what we're discussing. So what changed post BZA 03-2010 was how the code is applied in situations involving fueling stations.
So, well, let me ask you this then. Is LED technology a lighting method whose time has come with respect to the broader category of signage?
Well, it's certainly here. It's ever present. I was in Providence, Rhode Island for a conference earlier this year, the Congress for the New Urbanism Conference, and there was a really beautiful old historic theater. I think it was a performing arts center, and they had an old marquee, and they had LED, changeable copy. I think they were advertising like, one of their shows or whatever. And yeah, I mean, it could very much be fitting. I think it deserves conversation about, with respect to specific building types, certain landmark buildings, maybe it's appropriate. We've just never had that conversation
Well, that gets
as a
to
community.
Steve's question, whether it's a structural change or whether it's an upgrade of a particular part of the structure. Let me ask you this, your last slide when you talked about the implications, consequences, to what degree the COA that we have a copy of, that HPAC
Yes,
identified it as 4 conditions.
yes.
Are those not enforceable?
It would be perhaps tough to enforce. Actually, I think it's earlier. Let me see if I can find it. Here we go. Static signage, no scrolling marquee, no moving images, illumination as recommended by the installer, attempted adherence to traditional character.
Let me ask it this way, do those conditions fall on you for enforcement?
I guess that remains to be seen.
Are you personally knocking heads if they don't do this exact thing for forever, is what we're asking? No.
Well, you said it would be tough. I guess you need to operationalize why it would be difficult or tough to enforce these.
Let me try and think of, I always like to use analogies to help explain things. Parking violations. Like cars can be moved. Let's say there's a car parked on the front yard. You could say, hey, your car is not supposed to be there, move it off the front yard. And they move it off the front yard, but then next week it's back in the front yard. You see what I mean? It's like a game of whack-a-mole. So the same principle could apply here. So yes, there are conditions. It's what HAPC chose to attach to their approval. They are what they are. We would hope that
But those conditions are binding, as we sit here in time and space.
I think that's a legal question.
Well, let me say this. I think that when Mr. Grove gets up and we have the testimony, my recollection was from the HAPC committee meeting that many of these conditions were the direct result of the application itself. So if the applicant is saying these are the conditions that we are asking for, it seems to me that the implication of that would be that they would follow them. But I agree with Zach's analogy. It's the old days when they used to chalk the tires. You move your car, move back. Yeah, there's a parking violation there, but you catch them at the moment of time when they issue the citation. So like anything else related to zoning, there's an assumption that people will abide by the nature of what they've asked for and what the
Right.
permit says.
But
And
here's
the,
the
and the
problem.
law assumes compliance.
Here's a problem, what if they sell it next year?
Pardon me,
What
sir?
if they sell the building and the operation next year? The new owner says, I'm just gonna do what I wanna do on this LED
Well, if
sign.
they've got a legal non-conforming use and they change the use, then they would have a problem,
Right.
right?
Doesn't transfer easily. Any other questions for Zach?
Yeah, I have a quick question. Do you have any insight, Zach, on why the applicant chose an appeal versus a variance?
I do not.
Okay.
Any other questions for Zach? Okay, thanks, Zach.
Thank you.
Jack, this will be you want to do cross-examination, or do you want to start the
I'm
presentation?
gonna do some cross-examination.
Appellant, Mr. Grove?
Thank you. I'm the attorney for Wiseman Enterprises Holdings, and before the HAPC meeting on November the 12th, I asked everybody to raise their hand if they'd ever been to a movie production at the Miami Western. And I did. You're nodding your head.
Oh, yeah.
Okay, that gives us historical character because nobody else is doing. So I remember it, back in the 70s, and it's changed a lot. Zach didn't mention other alterations to the structure that have come about in recent years, in particular the sky deck that was added along Parpler, and the building has been substantially altered, although it is functional, and it's a very viable hotspot for Miami students in terms of their social functioning off campus. I'm sorry, I'm recovering from a virus, so my voice isn't holding up. At the HAPC meeting, we heard abundant testimony from Professor, I guess he's an assistant professor at UC, Joss Kiley, and he is both an architect and he has his PhD in architectural history. And he rendered an opinion having to do with the appropriateness of an art moderne structure to have updated lighting technology as part of the lighting component of the marquee. The marquee being a non-conforming, lawfully non-conforming structure that's true to the original architecture, as would be most theater buildings of that period. And then the lighting source being direct lighting, also being lawfully non-conforming, that's affixed to the lawfully non-conforming structure. If you're following me, the structure's non-conforming and the signage on the marquee are both lawfully non-conforming. So there is a general right to continue, and it's a valuable right, a lawful non-conforming use. And one would have to ask, if the marquee can't have lighted signage, what would it look like? A blank fascia, or something that would have a mediocre appearance, which I don't think would be good for the community or for the structure. And so the application really has to do with what kind of maintenance are we able to perform, replacing the fascia and the electronic components, because the existing dimensional lettering is obsolete, it's no longer in production, you can't get the letters, so you can't maintain the signage that way. There's a duty of sign maintenance, it's an affirmative duty, which Zach did not mention in the code, And we may see some examples of photographs tonight where signing is not being maintained, and it's not, and the lack of maintenance is not being enforced. So I think that we have vastly difference of opinion. We have the sign company representative, Vince Clusty, who's here this evening to explain the lighting technology and the replacement that is being proposed. And Thomas Bridenstine, who's an expert land planner, graduate of Miami University, with experience in historical structures, in particular the village of Glendale where he resides, and he is also an attorney at law. And he'll be rendering his opinions with respect to the application and the errors in the zoning administrator's interpretation. So with that, before I get started with testimony, and I do want to reserve cross-examination for Zach, Mr. Conard and I spoke earlier today, and we have various stipulations to make to complete the administrative record. And one is the certified copy of the HAPC hearing. The court reporter has provided a certified copy of all of the testimony with all of the exhibits that were provided. In addition to that, the HAPC approval letter, which followed from that with the conditions that you've been talking about. I think we had a 2.5-hour hearing. It was very conscientious on their part. There was abundant discussion. And it's significant that the HAPC guidelines require the HAPC to apply the sign ordinance. And so much of the testimony had to do with the same issues that are being presented tonight. And they determined that it is appropriate. So I think that's very significant in terms of your own interpretation. And we have Professor Kiley's report, which was in evidence at the HAPC, and Mr. Conard has agreed that we can stipulate to his report in lieu of requiring his testimony tonight. That was at his request because he had a personal conflict to arise. I didn't know at the time that I spoke with Chris this morning, but he has a document going to publisher, and he is up against the deadline, and he needed to finish that, and he was greatly appreciative of the consideration.
Excuse me, sir.
we have-
Mr. Chairman, can I ask a question?
Yeah.
Yes,
So that was available in November, this letter, when you went to the HAPC hearing?
he testified, yes, and that is one of the exhibits that,
Why didn't we get it sooner? Why did we just get it today?
well, because I expected him to testify, that's what I was explaining, and he asked to be excused. And Mr. Conard agreed that we could stipulate to his report.
Okay.
Yeah.
And we've got the transcript. I mean, the effect of that really is that when you deliberate, if you feel as if you need opportunity to review that evidence more completely, then we would just suspend the deliberations. You could review that independently.
And that'll come up,
convene in
that'll
December.
come up in deliberations. But we have copies of the HPAC letter and the report from Professor Kiley.
And part of the
And
significance
you've
of
seen,
that,
and everyone has seen those. The appellant is asking us to stipulate that those are submitted in evidence. Does the city stipulate so?
What I'm expecting is that Mr. Grove, well, we've got,
I gave you the transcript.
we've got the transcript. I think that we'll mark them as exhibits once it's all done.
Okay.
Because we've got to get Zach's report in as well. And I'm working on getting those together while
All right.
Jack's talking.
Chris, I think that we should probably use a different numbering or lettering system than was used in the HAPC, because if later on we need to refer to them, it would be confusing.
No, I agree. I mean, my thought would just be we would call the BZA the exhibits 1 through, unless you want them tied to a party.
I was gonna suggest, since they were 1 through in HAPC, that we do A, B, C here.
That's fine.
And that would avoid that confusion. Okay.
Makes sense.
Okay, so having to do with Professor Kiley's opinion and report, and this is significant in terms of the historical character Zach mentioned that the Smith Library refers to it as Art Deco in its original design, and that is correct. The Oxford Historic Inventory refers to it as Art Moderne. And what we learned from the hearing was that Art Moderne followed from Art Deco. It was very much the period of the late 1930s. It was representing the frugality of that era, at the time of the end of the Great Depression. But it was the first in terms of architectural styling to incorporate lighting as one of the architectural elements. And it also incorporated new materials, new technologies. This is from the transition going into modernism. So the examples that he provided, even having to do with locomotive design, automobile design of that era, sleek and lustrous and other kinds of finishes. Neon lighting, for example. And the old Miami Western fascia that you saw represented all of these. So his opinion is that it was appropriate because it continues the functionality. And one of the things that we discussed that was really significant is that the sign ordinance in Oxford does not regulate sign technology. It refers to the direction of lighting, whether it's direct or indirect, and you saw the examples. But the electrical components, the wiring, the sensors, the transformers, all of those kinds of devices are not specified. And there's no indication of preference for incandescent, for metal halide, for neon, for LED, for the various types of halogen, for example, that have seen changes in just the last 20 years. And I know in our own household, we used to have incandescent bulbs, and they're mostly now all LED. And the same with our stables. We have some old halogen, and I would gladly replace them for heat control and energy efficiency with LED as their time comes. So that's to your point. I would like to have Mr. Clusty to come forward and explain, because he is very expert in this area. He has photographs of another theater in Cincinnati area, Clovedale, where this application was provided, so it's representative. And he can explain the technology, the pixel resolution, and the maintenance need. So, Mr. Clusty, can you come forward? I may have questions of you along the way, but because of, I don't want to stand too close to you.
All right, no problem.
You need to state your name and business address for the record.
Vince Clusty, 3160 East Kemper Road, Sharonville, Ohio. I've been in the industry 37 years now. I've been selling the Watchfire product for about 20. So I've seen the technology change quite a bit. I know there's a lot of stigmatism tied to the resolutions and what you see and what you've commonly seen in some of these places compared to where the technology's come. I do want to show you the resolution, two samples of that here in a minute. We did recently, can I do handout? Got
Sure.
Yes.
So, we did, fortunately, won the grand prize in the United States. We're featured on the cover and in the back of the Watchfire catalog.
Would you give a copy, please?
And then, okay, I only brought 2 of them, but I did bring 5 of these. This is Coverdale Theater. We did about a decade ago, so the resolution was not comparable to.
Can you hear him?
Yeah, just barely.
Sorry about that.
But you were saying that the Covedale resolution wouldn't be the same, that this is a.
Covedale, they did not, the 6 millimeter's only been out about 2-3 years. They have a 6, 8, 10. We had proposed a 10 several years back. The one thing I wanted to clarify too is the usage. I think Mark, the ownership is in good faith, want to operate this the correct way.
Mr. Klutz, could you please just speak a little bit
I've got,
louder?
sorry. I've got 100 boards I mentioned in the greater Cincinnati market. I do not know of one that flashes or changes. The state law, ODOT's rule is 8-second hold times. I do not know why that wouldn't apply through your city. So the encouragement is they transfer in 3 seconds or less to the next image, and that image holds at least 8 seconds. That's the ODOT rule. So when you see a billboard, the traditional ads are 6 of them. I don't know who came up with the science, but across the United States, you're gonna have 6 advertisers on those. And they change every 8 seconds. And they change within 1 second. That is his intent, to use that per the rules of the state. So when you think of flashing, moving, there is software that comes with it. You can have party balloons and you can use some of that software, but it's encouraged, in his good faith, I don't think he would ever, want to not keep you guys happy. He has mentioned using it for city events from time to time. The other concern I had was the cabinet is 3'5" that goes into the recess of the old sign. The actual height of the live area is 3 feet, so that is one of the things we would be able to keep within code.
So you're replacing it within the same area, it's not an enlargement of the sign?
Correct. So it'd be the structure, that's why Covedale was a great example. Ironically, whoever built that structure, it was built exactly the same, because once we opened this up to survey, it was to a T, the same manufacturer, which I do not know who that is.
I'm sorry to interrupt. I need to plug something in. I'm very sorry. Can I just get a minute? Thank you. Sorry.
You said it goes 8 seconds in. Does it,
It
can
would
it go
hold.
longer?
You can, yes, you could hold, you can program it to do anything. You could put your Christmas ads up today so that software timing, correlates. But yeah, you really don't want any image up there less than 8 seconds. I would encourage even a little longer in his usage. I'm not gonna get involved in that part of it, but I also am not a big fan of white backgrounds. If you look at well-used ones, I own my own 17-foot by 28-foot tall one on 275. And if you look at my ads, people compliment me all the time. They're not sure why, but it's because of the usage. Black backgrounds are much better and less, concerning at night. The bright white is you just won't see many of them like that. Because we talked about it one time, well, do you want to try and mimic that build, the marquee and have white and black copy? And it would be obtrusive.
You mentioned at the last hearing that the lighting brightness modifies through the course of the day with changes
Correct.
in ambient lighting.
Yes,
And
the
can you
nits,
explain that?
the nits can be controlled up to 10,000. The Watchfire being one of 2 of the top manufacturers in the country, Daktronics and Watchfire. So they self-dim so that it's brighter in sunlight and then darker, or, dimmed down at night so it's not as powerful. You need the extra nits during the day so you can drive that image in the sun.
Questions, Steve?
Yeah. On this handout you gave us.
Yes.
On the 3rd page, it shows some construction going on.
Yeah, that's what it looks like when you pull those take those faces out and that cabinet that holds that, and then
Okay.
we go right into those.
I got you. It looks like to
recesses.
me that's a structural alteration. Is that a fair understanding of what you're doing there?
No, the marquee was on tack. It had nothing to do with the actual structure itself.
But you're putting a new unit into the marquee
Yeah.
structure itself. So
Yeah,
you're altering
it's a
that structure
self-contained
somewhat.
cab, similar to the cabinet that will come out. The
Right.
way it's built, we'll go back in
You
there.
don't consider it any kind of a structural alteration?
We might use a little bit of angle iron to
I'm
just
not sure I
secure it.
heard you correctly, or whether I just misunderstood.
Uh-huh.
This 8-second issue that you brought up.
I should probably explain it better. Consider it like a slide presentation.
Right.
So you would bring up that image and hold it for 8 seconds. You would go to the next one in less than a second. The state law allows 3 seconds.
That's a state law that allows
Safety.
signs of this nature to function with
For
a changing
safety.
image.
Yeah, for safety and,
But the COA indicates that there will be no changing images, I believe. Moving images.
no moving images. It's a slide, it literally comes up in front of you and the next one comes up in a second. So you'd have to be watching for that transition. It's not a slow transition. It's not, nothing's technically moving.
So you're talking about messages on the board.
Yeah, or an image.
Those will be changing? Is that, again, I'm trying to understand.
Right, you would
Every
just
8
have
seconds.
one solid image.
Every 8 seconds, it'll change.
It could go to the next
Party
image.
tonight, free drinks tomorrow.
Karaoke
Go to
night.
church on Sunday.
Yeah,
Okay.
yeah.
I want to explain.
But not in any less than 8 seconds is the state rules. So there would be no value to him operating.
Why don't you do that in the form of a question, Jack, rather than a
Well,
statement?
it has to do with the appeal. We stipulated that we'll comply with the no flashing component that's in the code. So Zach brought that up. The lighting brightness cannot change within a 2-hour interval. And we've stipulated that it will not be in violation of the flashing regulation. So that's one thing. And then the HAPC has superimposed other conditions that there will be no scrolling, so that's like, moving images. And all of that came about as a result of the testimony that they heard. The technology can allow you to do lots of things.
I understand, yes.
Okay, but the good faith component was that we're going to respect historic character. They did not put a regulation on the color, so the color of lighting or the color of the background. And so and I think that the question is, you're changing the the lighting components. It's going from neon, or no, excuse me, not from fluorescent.
Yeah, and I think it's currently actually LED
Oh, it
in
is.
place of the fluorescence.
It's
I think
currently LED.
Yeah.
Okay.
We don't do much fluorescent anymore, so they do make products that you can use the sockets from the fluorescent.
So you have a current LED bulb,
Yes,
okay, you're changing those components
we're taking those out.
with a new LED feature.
Yeah, I wouldn't compare the two exactly.
Well,
but
because the
they
other
are
one's an
LED.
elongate bulb,
Yeah,
right?
Yeah,
And this is an LED that's on the sign fascia itself,
yeah,
okay? Instead of backlighted,
correct.
okay?
And I think now.
And you have an illustration of what's there with your application is somewhat deteriorated.
I need some, just a step back and some operational definitions. We're throwing around some terms about, and some promises about what the technology is gonna do on this sign. Flashing, that refers to the 8 seconds, is that correct?
No.
No. What does that
Flashing to me
refer
is.
Because I was just told there'd be no flashing.
No, there wouldn't, but you would.
When you say flashing, what do you mean?
Nothing's flashing. You're using the term, flashing is, to me, is bulbs.
No, Jack used that.
Flashing is
For us
bulbs.
to understand what no flashing means, we have to have an agreement on what flashing would be.
Correct.
So when you say no flashing, you're saying there will be no what?
if you went 8 seconds on something, then 8 seconds, would you consider that flashing?
Yeah.
Yeah, so let me ask it this way.
Well,
When
when
you
you go down,
say
the- when you,
flashing, do you mean the frequency of message change?
correct, you guys determined flashing.
No,
Flashing,
that's what Jack said.
And we're not talking about strobe light here,
Yeah.
but
Yeah.
it's changing different colors
Yeah.
and different,
The city sign
flashing.
ordinance defines flashing sign, and the brightness of the sign cannot change within a 2-hour interval.
Brightness of the sign.
Yeah,
How about the image or the letters on the sign?
doesn't regulate that.
Okay.
We have stipulated that it will not be a flashing sign, meaning that we will stay compliant with,
The 8 second.
with the 2-hour regulation that's in the city ordinance. That's part of the application, that's part of the appeal.
So what would be on the message on the sign would remain there for a minimum of 2 hours.
I don't understand how the message correlates to the brightness, and maybe that's
It doesn't.
something that he can answer.
each image is gonna
I'm
be
not a sign
different.
expert.
It-
I think the distinction we're trying to make is if a promise is made, there's not going to be flashing. Does that mean one image changing the brightness? Or would that mean a Rolodex of images changing quite quickly, even though the brightness stays the
That's a
same?
good example of
Yeah.
a Rolodex.
Yeah, are you gonna
The
hit me with
library.
karaoke night, church on Sunday, free drinks
Right,
tomorrow, all
right.
within 5 seconds?
No,
8
Okay.
seconds?
8 seconds.
it's illegal.
Within 8
Illegal.
seconds?
And then they're promising they won't do it for 2 hours.
No.
Well, no,
I don't want to promise, I want rules
Hold on.
No,
that
that's
have
what
to be
they're saying.
enforced.
Yeah.
Let's stop for a minute,
If I could
Right.
intervene for a second.
please.
When we're talking about the context of what the COA says, it used the phrasing static signage.
Right.
The static signage, I will share with you my interpretation from having been there. Others can disagree with that. But the intention was that it would be events for a singular event on a given moment in time, static. Then when it was time for the next event to be rolled on, it would be there, static. And then another component that's come up to clarify is that there was this mention of the black background. In the photos that were shown with the application, that's why the number 4 is there, attempted adherence to traditional character of the signage on the marquee, which you've alluded to. There's many ways the sign image could be manipulated based upon the software. And when I say manipulated may not be the right word, but you can present different images in different colors because of the bulbs.
I think it's better to, let's say you took a picture of a scene, a mountain scene, a photograph. These are photographs really, essentially, and it's how long do you leave that up? And if you take a picture of a forest, those colors are gonna be different. There's nothing to do with brightness. It's still performing the same way, and whatever the sun or the time of day is allowing it. So you could never write a code that said you can't change the brightness in 2 hours. It just wouldn't work that way, because it's a dimming process that helps make them, these companies want people to like their products. They're not out to create issues. So they've addressed a lot of these issues over the years. So it really is a slide presentation. You could control and dictate how long you want that image to be up. If he changes it, I'm suggesting you change it in 1 second so you don't really feel it, you don't see it, it's not a flash. It's like, no one says when you drive down the highway that the billboard just flashed. When all these boards have changed from image to image,
But what's the frequency of that change in a 1 hour period?
75 times. I'm talking traditional advertising and the
Right.
way it's used at 8
But
seconds.
not what we're talking, not the case we're talking about.
That would be, that's up to everyone else. I'm just here for what would I do if I owned it? I might go to 8 and 10. 12 seconds. I might go for an hour for some stuff. I don't,
Well, I guess I'm just trying to figure out then, the
We don't
COA the COA condition, it's a static image. No
and that's what we
scrolling
consider
art,
a
no
static
moving
image
image.
for 8 seconds. That's where that term goes in. That's a static image. That 8-second period would be static. Would you guys like to see the resolution
Sure.
issues with the product? This is the 6 millimeter from a distance. This is a 16. This used to be the most common about 8 years ago. They do have a 10 that looks more like this than an 8, and he has chosen to go with a 6. So and there's only about 3 to 6 millimeters in the city. So it is a nice refined board. You want to see.
If you could keep your voice up, please.
You want to touch or feel them or look
Not
at them?
really.
All right.
Thank you.
Can I answer anything else that would be
Any other
helpful or
questions?
explain it better?
Mr. Klutsky?
I have one question.
Yeah.
So it seems like the technology's moved around a lot and developed a lot in the last few years.
Yeah.
What is being proposed, would you say, in your professional opinion, longer lasting as a product versus what
We're
currently
seeing,
exists?
I've got stuff out there where kind of the end of life is seen to be about 14, 15 years. Where we're.
Versus
and,
like-
And that we've changed so much technology, we can't get the parts on some of these, but yeah, you should get a good solid 10 years easy.
Versus what's
Can you
existing
explain
now?
the situation with the existing dimensional letters?
Yes, strangely, the dimensional letters are not available in our industry anymore. The only ones available are the flat ones, so he would have to convert to a flat letter that really don't go with that big of a marquee. They were always dimensional, so you could hang them on because people were using usually an arm to do it. If he was forced back to that, the flat, he really would damage new signage within a couple years because you've got to use a suction and you kind of bang it and go up and down into the retainage of it. And they do collect water and ice, and it's nearly impossible through the winter to change them very effectively at all.
So the film type lettering that's available in some establishments
Yeah.
doesn't have equivalent performance characteristics
Of
to the dimensional signing that's there now.
No, doesn't have the same appearance at all.
Okay, and then what about the maintenance requirements with what is being proposed, the LED fascia that you're talking about?
The quality or the longevity, life. I would like to think he'd get, it's 5-year warranty, so we don't see many problems within the 6, 7 years. We might have a module go out and replace it, so. The ones where you see the quilting effect, we call it, where you can kind of see the different brightnesses of the squares, that's just an aged board. And people haven't dialed in those colors, because they do have the ability, as they age, when we service it, we can actually dial that new board down to match the ones that might have been there 6, 7 years.
Mr. Chairman.
Yes.
So it sounds like to me, this is being done to prolong the life of the sign. Is that fair?
Yeah, I don't know what else he'd do with them.
Right.
if
And
you wanted-
also, what's he doing now? He's still using the old system with the changeable?
Well, he's trying to be creative, running out of letters to spell the right things.
What do you mean running out of letters? So they get broken or what's happening?
Yeah, I guess over time, broke
Okay.
and ran.
And do you know
Not
when
sure
they
it's
quit
exact.
making those letters? You say they don't produce them anymore. When did they stop doing that?
About, I think our documents found about 4 years ago, because I talked to the Sign Museum. I'm very close friends with the Sign Museum in Cincinnati, if you're familiar with it.
Okay.
And in discussing that with their cure, the one gentleman there, he swore he could get them. And I said, I need to know. And he made calls from my office. And I was quite honestly shocked, because with all the OEM type things, I would think there's somebody, if they put the money into the molds, they might be a lucrative business still, I would think. So I'm kind of
Thank you.
surprised to see.
I have a question. Clearly, we're not supposed to have flashing or animated signs. Clearly, and there's probably a difference in what we believe flashing might be. And since the owner is having a really difficult time coming up with the new signage to replace when it gets damaged, why couldn't you have this technology and this equipment you're talking about just be a static sign, like our ordinance says? It's static, but the new technology. Why does it have to be every 8 seconds?
Oh, it doesn't. I was just reaffirming the state laws. If you're concerned, call it state.
But that's not what the plan is.
Yeah.
That's not what the plan is. The plan is
I-
to have different things come on the screen continuously, whereas now it's static, which is an ordinance.
I think that the static that the COA says was intended as you were
Right,
saying.
that's the way I read static. Clearly, when you introduced the 8 seconds, that was a broader technology
That would be an 8-second
discussion.
static.
That
8 second.
really doesn't
Yeah.
apply to this case, is that correct? That
I think-
8-second change.
I think
So the
Jack
act-
can clarify what the applicant's intent is as it relates to static. Because we heard that testimony at the HAPC that was, that's the capability of the technology.
Correct. Right.
Not the intended use with the Brick Street structure.
That's my understanding of what the COA says and specifies.
Because COA did say you can have continuous messages every few seconds.
No, that's
No.
Right, that's
in
not
fact,
what
they
they're,
expressly
it was
said
still
no
static, that's why
scrolling
they approved it
signage,
as static, right?
That was driven by what the event was, and the slide, in the application, and then the slide number 8, that could be pulled up again when Zach can get up there, right there, that was part of the application on what this 6-millimeter sign would look like, which would be, at least to me, appears to be somewhat consistent with the historical sign use. Is that a fair statement? Mr.
I don't
Casey?
think you'd be happy with that white background every night. I just think it's,
Yeah,
it
that-
would
okay,
be
it's not,
overpowering.
the background is what, but it's,
So you would say black background with white letters?
At times, yes, or colorful logos on a black background.
that's-
And what I mean by
that's what I
black
mean.
is that
I
that
don't think
portion
that's
just
what
doesn't light up, that design.
Yeah.
But I believe their interpretation of static was just the no flat, that was a follow-up to no flashing, no animation, I believe.
okay.
But I don't think anyone was trying to make.
Any other questions for Mr. Klutsky?
So you do have LED now, and you're talking about changing the electrical components to something else with LED,
Testimony.
all in the same size.
He's testifying.
Good. So, this is just a point of clarification, because I hear concerns and questions. At the HAPC, one of the members, the female members, and I don't recall her name, was concerned about, at holiday time, fireworks going off and exploding. Sometimes there are images of flags blowing in the breeze. And that was the discussion that led to static image. We stipulated we're not going to have fireworks, flashing. The images remain static. And in the original application, we stipulated that it will comply with the city's sign ordinance that prohibits flashing signs. And that's a 2-hour regulatory interval.
So the intent is to follow the city's
Yes,
2-hour.
So-
that's what we're here to follow the
No
regulation.
shorter than 2 hours. It could be longer than 2 hours before a sign changes, but it would be no less than 2 hours.
Yeah, in
Okay,
terms of.
then I have another question, another operational definition. Static images, you're stipulating that. Are you agreeing to that condition? For the COA anyway.
The owner is compatible with the stipulations that were put on by the HAPC.
Okay.
I think it was very conscientious on
Static
their part.
images.
Yes.
Static images.
Yes.
And we know what the city ordinance requires in
Yes.
terms of changing or flashing or
That's correct.
whatever verb you want to use. Now we need to define image. Do we mean letters, or do we mean some sort of other graphic
Well, the
picture?
technology allows a broad array. Getting back to Art Moderne introduced color. It introduced imagery. And so they did not regulate that by the HAPC. So yes, it could have another image. They were asking the owner to to look at the historical character, the application shows an image that almost replicates what is there now with the dimensional letters from the viewer's standpoint. One of the photos that I'll be showing you is a nighttime photo of what is there now. And if you look at that Covedale example that he provided, I think it's very helpful in terms of understanding what the static image can look like. The technology
An
allows.
example here with a photograph. It's
Yeah.
got several different types of images, not just one image.
Technology allows all kinds of images to be installed. And it falls then on the operator to determine the nature of the image or the content of the promotion. And that's where we get into areas that Mr. Bridenstine can speak to, and it's not up to this board to determine constitutional matters, but we get into regulating commercial free speech in terms of the image. The Tip City case that I cited didn't involve a sign at all. It's a mural directed to the interstate highway. I've seen it driving by. It's a mad scientist with a beaker. It's pretty cool. And they determined that that violated the sign ordinance, and the Court of Appeals said, no, that you're regulating commercial free speech. So there are limits in terms of the regulatory process on what ordinances can be passed, what board interpretations can occur. If the use is allowed, we avoid the constitutional issues. This board doesn't have the ability to decide constitutional matters, but it's one of those issues that arises in the background depending upon the outcome of this case.
I understand the First Amendment
Yeah.
issues. I just wanted to make sure that I understood what was meant by static image.
Nothing
Word
moving,
image
no
could be a letter-
scrolling.
It could be a letter, a word, or a picture, or some other graphic.
Yes, whatever the image is, the LED, it's what's programmed into it. So it could look almost like the existing changeable copy letters. It could introduce a different color. It could have a logo. If it has to do with a Miami event, maybe it'll have Miami's
Block
M on
M,
it, okay?
sure.
They had a crawl last Friday night, I'm told, down to Goggin, and it's the biggest attendance that the ice arena has had in ages. It's a collaboration of private enterprise and the university, but it was very successful for promoting Miami's sports team.
But is it fair to say that though the application features a photo attempting to replicate the existing manual changeable sign, that is not exclusively what the owner intends to have?
Yeah.
Because the technology presents the ability for different images, it will not strictly always be an attempt to replicate the existing manual changeable sign.
I think
Is that fair?
gets into the owner's desire to utilize the signage and to promote his establishment. This is a major investment, and it's, I think, an improvement over what is there now, especially considering the safety side of it. In the application, one of the things that we do in zoning is we look at public welfare and safety. And it's not mentioned in the administrator's decision, but the manual changeable copy and the use of the latter is dangerous. And they did have an event some years ago, I referred to it, where one of the employees was spilled on a ladder and suffered head trauma. This electronic copy change avoids the safety hazard. This is also a very high pedestrian area, and you don't necessarily want people on ladders where a lot of pedestrian traffic is moving. Things can fall down. So I think, it's a technological advancement. Mr. Russo, you mentioned his LED come of age, and now is it of time? And it most certainly is. It's displacing other technologies because it has superior characteristics. And we're seeing it in our lives. I mean, my profession has changed as a result of computerization and the things that we can do. Not all for the good, but there are a lot of advancements. And, that's for, the city's in the process of doing a sign ordinance change right now. Mr. Moore alluded to a moratorium, other things that they need to do to catch up. The United States Supreme Court case was paramount on this issue that imposes a strict scrutiny standards 10 years ago. So the city is in much need of a change. Just a few months ago, they changed the variance guidelines that you're familiar with to introduce precedent. But I do have to say that Catherine Dale's interpretation is incorrect in terms of LED. LED is a form of electronic technology, and the code does not distinguish among the kinds of electronic technology.
Yeah, the code doesn't use LED
No,
as a term.
it uses electronic, and LED is a type of electronic.
My interest was getting some definitions of what static image was,
Yeah.
and now I've got it, and that is, it
Yeah.
could be letters, but it could also be some other graphic.
Yeah, sure. Okay, now I'll have Mr. Bridenstine come forward, and sir, could you introduce yourself and your background, and then tell about your report?
Certainly. Thank you, Jack. Thank you, Mr. Chairman. My name is Thomas W. Bridenstine of the law firm of Bridenstine Legal Services, LLC. I'm based out of my home, which is in historic Glendale, Ohio. By way of personal background, I have a bachelor's degree in urban and regional planning from Miami University, class of 1984. Once I graduated, my first job out of college was with the Boone County, Kentucky Planning Commission. In that role, my job was the zoning enforcement officer. I see you smiling. Does that ring a bell?
I have many students who went into planning.
Oh, is that right? Okay. Well, at Boone County, again, my title was the zoning enforcement officer, which essentially was the zoning administrator for all of Boone County, much like Mr. Moore's role is here. So my role there entailed reviewing and approving sign permits, making appearances before they called a Board of Adjustment, your version of the BZA. Also interpreting the code and enforcing the code. So when I was the zoning enforcement officer, I came into contact with many different attorneys, and I realized I could be an attorney. So I went to law school at night at Chase Law School, graduated in 1993, and since my graduation, at that point, I've focused my practice probably 75% at least on zoning and land use issues. By way of a personal background, as opposed to professional, where I live in Glendale, I'm also the chairman of the Planning Commission, the Glendale Planning and Historic Preservation Commission. While there, I marshaled the adoption of our historic guidelines through the Planning Commission and adopted ultimately by council. I happen to also be the chairman of the Glendale BZA, so I know exactly the role that you're sitting in, and I can empathize, quite frankly. So that's by way of background. That's gives the basis of my expertise and why Jack hired me. And he asked me, and I gave an opinion. I believe he's given you a copy of my report to opine as to Mr. Moore's interpretations and administration of the code.
Before you get into that, have you previously testified as an expert with respect to planning and zoning issues?
I have those items or those opportunities, and those former testimonies were listed in my page 2 of my report. I can go into detail, but I think it's
Well, just that you've done this
certainly,
before.
yes. This is the 5th time that I've testified as an expert in this capacity, broad capacity of land use law.
And I'd like the record to reflect that we just received this report.
Yes,
We handed it out
just
tonight.
circulated, yes,
Yeah,
that's correct.
we haven't, this was not made available to us.
No, it's
prior.
dated today.
The opinion, let me fast forward to my ultimate opinion, and that is that Mr. Moore erred in his interpretation and administration of the sign code and of the nonconforming code. And in fact, I believe that, in my opinion, the sign that's been presented to you tonight should be a permitted use. The basis, the very core basis for that interpretation, or for that opinion, I should say, Mr. Chairman, begins at page 4 of my report. There's a list of legal standards there that you may have not heard before in your capacity as members of the board. But the very first, the highlighted ones are key, and it certainly bears direct quotation. Zoning ordinances are to be construed in favor of the property owner because they are in derogation of the common law and deprive the property owner of uses to which the owner would otherwise be entitled. The second one is restrictions, and I'll paraphrase this one, must be strictly construed and cannot be extended by limitation unless they are clearly prescribed in the code. The law does not allow zoning to be contain limitations by implication. In other words, you can't imply something in the zoning code. It has to be clearly stated in order to be enforced and interpreted. The corollary to that is on page 5. The law requires any ambiguity in the zoning ordinance to be construed in favor of the property owner. So that's sort of the core basis for any zoning decision that comes out of Mr. Moore's office. He should have been leaning in favor of finding a way to make this application approved, unless there was something clearly stated in the zoning ordinance that says that this kind of sign is not permitted. And in fact, continuing on,
It does say that.
I'm sorry?
It says that in the code, specifically says that in the code. You can't have a sign that's not permitted under the code. You just said it,
Well,
it doesn't say
yeah,
that.
well, I'll
but
get to that too, because this sign is permitted. I'll present to you as by way of opinion. Mr. Moore talked in great deal about his application of section 1137 of the zoning code, which provides for normal maintenance, which includes painting, replacement of surface panels, and repair of electrical devices. He seems to interpret that to mean that those are the only types of normal maintenance that would be allowed for the sign. Again, applying the core principles that I described earlier, that list of normal maintenance should be broadly interpreted to include an application, to allow the application that's before you today. And in fact, that provision also says a non-conforming sign shall not be structurally altered to prolong the life of the sign. Well, that's directly at odds with other provisions of the code that says you shall maintain the sign. And of course, I think you all realize that any maintenance is going to prolong the life of a sign. So again, those provisions should be expansively interpreted to the sign that's before you tonight. In a similar vein, Mr. Moore inserted his belief that there's a like-for-like replacement component that he read into the code. And therefore, because what is presented to you here tonight is not exactly like-for-like, it shouldn't be permitted. Well, I submit by way of an opinion that is an implication that's prohibited to be used as a tool in interpreting the code. There's no like-for-like provision that's found in the code. Therefore, it should not have been used as a basis for his interpretation, in my opinion. Of course, I think it goes without saying that, and I maybe stated this before, that normal maintenance, or just maintenance in general, should be encouraged. And that's really what we're talking about here today, is a form of maintenance of the sign, in my opinion. The section regarding the loss of nonconforming sign status, that's 1137.10, I should say, says that the structure of a sign, if the structure of a sign is altered in any way except toward compliance of this chapter, it shall lose its nonconforming legal status. But there's an exception to that very provision that says that doesn't apply to changeable marquee signs. Now, I know Mr. Moore has interpreted to mean that just means the letters, the changeable letters on there. The code doesn't say that. If the drafters of the code wanted that provision just to apply to the changeable letters on the marquee sign, they should have said it doesn't apply to the changeable letters on a marquee. Instead, it's my opinion that the drafters of the code specifically allowed for a situation in which marquee signs could be changed, non-conforming marquee signs could be changed in a way that's not towards general compliance of the code. Mr. Moore talks in his opinion and here tonight about changeable copy signs at 1151 of the zoning code. It strictly means mechanical, electronic, or manual means. Again, I think that code needs to be broadly interpreted to mean the type of sign that has been presented to you tonight. Certainly the manual copy is permitted as a non-conforming use, but so should the changeable copy, which we already heard today is going to be electrically changeable. So this is a changeable copy sign. Now, diving deeper into the code, it says that those changeable copy signs are only permitted to advertise fuel at filling stations. And as you've heard today, there's a lot of talk about that being an unconstitutional restriction on commercial speech. The content, it's content-based interpretation, which is presumptively unconstitutional. So applying strict scrutiny, I'm convinced, and it's my opinion, that that would not withstand a court challenge. In fact, I think the end result would be that changeable copy signs are permitted, and not just for fuel stations, and not just for the price of fuel. If you're going to allow them for one, they should be allowed for all, in my opinion. That is based upon my read of the Reed case that you've heard about today. Another point, Mr. Chairman, is the statute, which is the last page of my report. It's 713.15, deals with how cities should treat non-conforming uses. And as you can read in that statute that's there, the law requires that cities allow the continued existence of those non-conforming uses, but there's no provision there that says you can provide that they be discontinued if they're changed or if they are altered in any way based upon the provisions of the code that Mr. Moore has already cited. In fact, the last sentence of the statute says that the city shall provide within the ordinance for restoration, reconstruction, extension, or substitution of nonconforming uses, in this case, a nonconforming sign. And I think that there's no provision in the sign code that I've seen that allows for substitution. So I believe, once again, interpreting the statute along with the code, there should have been some allowance for the substitution of a nonconforming use. And of course, if the municipal ordinance is in conflict with the statute will prevail. I should have stated this at the very front, Mr. Chairman, and perhaps you already know this, but the continuation of a non-conforming use is a valuable property right. And again, constitutional law is clear that those valuable property rights are protected by the U.S. Constitution, the Ohio Constitution. And again, the interpretation of, in my opinion, is under review tonight, fails to protect the vested rights of the owner of this property. I think that hits all the highlights, Mr. Chairman.
One thing I'd like you to address, did you have
Yes.
a chance to look at the city's new economic strategic plan? I did, and I addressed that at the bottom of page 7, Mr. Chairman, of my report. And in fact, there's what's called a key findings and a recommendation within that economic development and strategic plan. And that recommendation encourages flexibility in the administration of the zoning code. Excuse me. Zoning flexibility?
Zoning flexibility. In fact, the actual quote is zoning flexibility, streamline procedures and incentives, implement policies and procedures to attract developers and end users to invest. And again, that's found at the top of page 8 of my report, page 3 of the strategic plan.
Thank you, Mr. Bridenstine. Board, do you have any questions of Mr. Bridenstine?
I don't, but again, we only just got this tonight.
Right.
I need to go through it to ask some intelligent questions.
Mr. Chairman, I got one.
Yep.
On page 8 of your brief, or whatever you're calling this, number 9, you state in the last sentence, nothing in this statute, and you're talking about the revised code section,
Right.
gives cities the ability to prohibit structural changes to a non-conforming use. Are you saying that what the client, or you, I assume you're being paid by the sign owner, is this a structural change? Because you talk about being structural change being prohibited.
Yeah.
It is a structural change.
The word structural I use broadly. I mean, structure is anything, in my way of thinking, in the use of that opinion. Now, I don't know if the word structure is defined in your code. I didn't find that, or I didn't look for that.
Well, there is a section in our code, 1159.14, 7, that talks about replacement of an entire segment of the structure. You're replacing a pretty significant segment of this sign structure, are you not?
That's my understanding. I'll have to concede to our other expert who's could tell what's being replaced and what's
I
not being
can
replaced.
see from the picture he gave us, that this is, and he mentioned it, you're taking out the existing structure that illuminates the sign and replacing it with an electronic device, basically, more or less a computer screen. Isn't that what that
If
means?
that's what Mr. Kluski said, yeah.
I just don't understand how you can argue it's not a structural, or significant, anyway, at least a significant change. That's beyond a maintenance or repair, right?
Sure.
Mm-hmm.
Just asking a question to this gentleman.
What you're seeing in that photograph is the lamps and sockets removed. The marquee is the same exact marquee structurally.
My question is not necessarily the structure, which you were hung up on. My thing is, we hear, this is obviously a change.
Yes.
For the better. I'm not arguing that it
Yeah.
wouldn't be for the better. My problem is the fact that all of you guys are saying that it's maintenance. It's not a change.
You didn't hear
That,
me.
I heard
Don't-
what each one of you all said,
I
and
didn't say
it's
that
a maintenance.
once tonight.
It's not a maintenance
I didn't
issue.
say that once tonight.
It is,
I'm here to
it is
discuss the
clearly
product.
a change. That's the problem that I have with trying to interpret what you all are trying to say, because it is a change.
I agree.
And a part of our ordinance says you lose that status if it is a change. And it's pretty clear that it is.
You would rather see the marquee taken off the wall.
You know what?
The entire structure.
Of course, you know,
I'm asking,
that's actually a ridiculous thing to say, and beside the point.
Well,
My
as a-
question is
as
this a
solving these
maintenance
problems,
or is
if
it
I-
a change?
Let him answer the
Is it-
question. You've asked the question about whether this is a change or whether it is, well, I guess Steve asked whether it's a substantial change.
Right,
Or.
I'm
or
trying to
this-
understand what
I
it-
think Zach mentioned that the structure was really the broader marquee. Did I miss that? Zach,
I'm sorry?
did you make the comment that the marquee was the broader structure?
I think that's a reasonable interpretation, yes. When I think of a sign structure, I'm often thinking of like a freestanding sign. So a sign that's posted on, a foundation or, so
Well,
the
help us
sign
out then.
structure.
What is the marquee in this case?
I consider it part of the structure. A marquee is part of the structure. Yes.
It would, some municipalities would call it a face change, an upgrade, not maintenance, but a face change, like a structure, a freestanding sign. If we go out and pull the faces or add to it, we didn't change the structure. We just,
Well, that's different.
the structure to me is the concrete foundation and the steel. On the marquee, to me, it's how it's attached to the building and the I-beams running back into the beam. That's the structure of that marquee. As far as load bearing, all of those things.
I have a quick question.
Yeah.
Do you know, Zach, if there's anything in the code that distinguishes between signs and billboards? Because I think my understanding is this technology is used for a lot of billboards.
Can I
Right?
just interrupt here? Are there any more questions for Mr. Klutzy? Before we go into asking some questions of Zach and.
Do you have more questions for Mr.
Well, that's a good question as far as the billboard typically is off-premise advertising.
Right, versus
So,
this
and-
marquee sign isn't a billboard.
No, not it's the same technology. Actually, it's higher end because you wouldn't use a 6mm up on a highway. You'd use
Yeah.
a 16 because you wouldn't need that. But-
That's all I need to know. Thank you.
Mr. Bridenstine, are you finished with your presentation?
I am.
Your testimony?
I am. And thank you very much.
Okay, any questions? Any more questions? Thank you. Mr. Grove?
Yes, I have some photographic images that I'd like to share.
We've been here 2 hours, almost 2 hours.
And certainly it'd be appropriate before we get into any discussions with Mr. Moore. So the first set, and I have copies to share, are the general streetscape on High Street. It shows Brick Street at nighttime, which I think is maybe more helpful in showing what the building looks like when it's brightly lighted.
There's another copy here, gave you two.
Oh, okay.
I'm sorry to interrupt, did you want these marked?
Yeah, they'll all be marked, we'll do that. So that's the streetscape. Brick Street, directly across the street. The next image are the buildings directly across from, excuse me, they're out of order. The next one is in your packet, the Circle K sign where the variance was granted in the historic district. And it's for an LED sign, and it shows the historic Ox College right in the background. It's a two-face sign, so the next image is from the other side of that sign, also projecting onto the historic structure. The next image shows the buildings directly across the street from Brick Street, on High Street, the south side, and it shows direct lighting signage for the Salon, Highview Apartments, and Extend Computers. Heading east, also on the south side of the street, is the direct lighting signage for the Bagel and Deli Shop in the historic district with the historic structure, the fraternity building at the corner of South Campus and High Street. And then across the street from that, the DuBois building, and which they received a variance for direct lighting signage on the front of that building. It's significant that there's an abundance of direct lighting signs throughout the uptown High Street area. Some variances, some lawfully non-conforming, but certainly prevalent. The next is photo display of the fuel centers in town, having
If I may interrupt,
electronic changeable copy signs.
doesn't the BZA rules say that applicants should limit testimony to 15 minutes?
It does.
It does.
And we are well over 15 minutes. I just want
I'm
to make
gonna
that
allow it
clear.
to proceed.
All right, thank
As
you.
long as you're ready to wrap it up.
And maybe, could you help make the point of the pictures a little more relevant for me?
I'm sorry, I was away from you.
The point, the relevance of the pictures, I'm not
Fuel
quite
centers?
understanding it, yeah.
Okay, so these are 5 fuel centers that are in Oxford. The Circle K, the Speedway, which is at South Locust and Spring Street. Going out on College Corner Pike, we have the Sunoco station. And you'll see from that photograph that the signage is not being maintained. It's in very poor condition. In fact, the electronic image doesn't even give a fuel price. And then the Shell station on 27. The other one on College Corner Pike is KDS. So this is illustrating how electronic changeable copy has been permitted for fuel centers. The last thing that and I just want to put it in the record, Mr. Moore has alluded to the Circle K case where a variance is granted, and I have the entire minutes and resolution of that particular variance as precedent for granting changeable copy, electronic changeable copy sign in the historic district. He mentioned the significance of the precedent.
Are you referring to this sign here, the K sign? Is that the sign?
Circle K, yes. Mhm.
And it's a fuel station, correct?
It is, that's
Okay.
correct.
No
All of these are for fuel stations, commercial,
They don't have the right sign.
extemporaneously here. We don't have time.
No, we do not.
And so, with that, I have a few questions for Mr. Moore, please. And one is, Mr. Moore, can we agree that the like-for-like language is your interpretation? That language does not appear in the zoning ordinance or the sign ordinance?
The term like for like does not literally appear in the ordinance.
Thank you. And we can agree that the sign ordinance does not specify electronic technology, whether it be incandescent, whether it be LED, fluorescent, halogen, or metal halide.
No, it does not get into that level of detail.
Okay, so you talked about your idea having to do with the code, and you referred to Catherine Dale's interpretation. We can agree that lighting technology has evolved greatly in the last 20 years.
Absolutely.
And how long have you been the planner?
Since January 2019.
Okay, and since you've been here, the last 6 years then, how long, when's the last time that the sign ordinance was amended? Do you know?
I don't know off the top of my head. When I first started with the city, I immediately noticed that the manner in which the sign code is written is clearly content-based and needs to be amended and corrected.
That's a problem.
That is a problem,
Yeah.
absolutely. So in my capacity as zoning administrator, anytime I am faced with a decision, when it comes to enforcing the provisions of our sign code, I'm always checking myself to ensure that I am severing or disregarding those elements of the code that are inherently content-based, facially content-based.
Your report referred to Art Deco design of the original structure, and then you mentioned in your presentation tonight that there is a difference with Art Moderne.
Yes, and I bring that up because I happened to listen to the recording of the HAPC meeting.
Okay, and did you consult the Oxford Historic Inventory?
I did not do that. I did not look at the inventory, but I don't think there was a reason to.
Okay, well,
At
if
that
it
moment.
specifies that it's Art Moderne, that would be significant, correct?
I don't think it's significant with respect to the case that's before the BZA tonight. I think
yeah.
it would be more a matter that, well, HAPC certainly has already considered and has already rendered a decision on. I think the architectural styling matters less with respect to the case before the board tonight.
And since you listened to the HAPC tape, you did hear them discussing the sign ordinance and the maintenance provisions, correct?
Yes, correct.
And they unanimously determined that this was an appropriate replacement.
Well, they applied the provisions pertinent to certificates of appropriateness and those that are pertinent to
Including the sign
the
ordinance.
historic commission, but
Including the sign ordinance, right?
they reference the sign ordinance, but there's matters of zoning that
Okay. So
They go before-
HAPC guidelines requires them to apply the sign ordinance, correct? And they did so. You listened to the tape.
I did.
Yeah, and
Yes.
they applied the sign ordinance, correct?
This,
Okay, he's answered.
yes.
he's answered
Okay.
it.
They don't,
Yes.
He's answered it.
so
Yeah.
the organization has no
Any other-
relevance
any
to
other
us.
I don't have anything further.
Okay.
Thank you.
I do have a question.
No.
For you, Jack. Why did you choose to go through an appeal of the denial of the permit rather than request a variance?
Well, I think that's a privileged matter in
Well, I mean, you don't have to answer it if it's a
in the
privileged
first
matter.
instance. But I will say on its face that there are different legal standards that apply. A variance requires a different burden of proof. This would be a use variance, not an area variance. So that imposes an even additional burden. There are problems with the city's interpretation, the application of its own ordinances. This is just a matter of interpretation. The maintenance allows specifically allows the replacement of the sign fascia and the electronic components. That's the way the code reads. And that is encouraged, and it's permitted, and it's an exception to the provision on losing nonconforming status. And the idea, if we want to talk about ideas, is to allow the continuity of a lawful nonconforming use with the state law mandates. So the city ordinance is very flawed, and this board has the duty to give an appropriate interpretation. And I appreciate the difficulty of your task, because you're told by your own planner that your ordinance is troublesome. And the way to resolve that is to allow this and fix the code. So I think it's a simple solution.
But we
Thank
don't
you.
fix
We don't
the
fix
code.
the code. We don't fix
Any other,
codes.
any other
We don't
comments?
fix-
No,
Okay, thank you. Then I'm gonna declare Mr. Knapp, I'm gonna declare the evidentiary portion of the hearing complete. We're gonna move to deliberation under our procedures.
Right,
We
but
deliberate
a
in private.
couple housekeeping items.
Yep.
One, you'll need to do a motion and second for private deliberations. I'm thinking that maybe you want to create a list of what those exhibits are. So we got to.
we can do that while you're,
Yeah.
and then we can confirm.
Right,
Yes.
yeah, okay.
Okay, so we need a
Second, oh,
A motion to go into deliberation.
second is.
second. We moved and second, all in favor indicate by saying aye.
Aye.
Aye, opposed, abstentions, hearing none. We are now in the deliberations.
What would you like to take back with you?
Everything,
You want the transcript too?
yeah,
All
everything,
right.
and you.
All right, let me see what we got here. If you would take the paperwork you can get, I'll take the rest of it. Okay, all right.
I have a motion to move out of private deliberations.
Motion to move out of private deliberation.
I'll second.
Moved and seconded, all in favor indicate by saying aye.
Aye.
Opposed, abstentions.
Mr. Chairman, I have a motion. So I'm going to move that we are going to continue in deliberations. We are going to take the time to review the record. After doing so, we may have additional questions that we might want to ask and/or legal advice from our law director. And that, at that point, when we feel confident to move forward, we will render a decision.
And you plan to continue the deliberations at the regular December
Oh,
meeting?
yes.
I would say suspend deliberations for an opportunity to review the record, and upon that review, there may be questions of the law director regarding legal opinions and additional questions submitted to applicant's counsel.
I accept that amendment, yes.
Okay. Is there a second?
A second.
Okay, everyone understand the motion? Everyone understand the
I do.
everyone understand the motion?
Yes.
All in favor indicate by saying aye.
Aye.
Opposed, abstentions.
We had discussion when you were back there, the next regular meeting, which you've indicated in your motion, is December the 23rd. And Zach was, that's what I just wanted to bring to your attention, if you wanted to adjust the meeting date.
We'll be,
Yeah,
we'll adjust it.
and right now, one member may not be able to be there, and so we'll have to,
Yeah,
we'll, we've got to coordinate calendars.
Okay,
Thank you.
And with the, I guess for the record, we do need to do one other thing, which is we will adopt the exhibits. We'll get you the exhibits, but we can formally adopt those at the next meeting. It's late, and we want to,
we'll do that at the next meeting.
yes, we'll do that at the next meeting.
Okay.
Motion to
Oh,
adjourn.
Is there any comments from the public? Hearing none, I'll take a motion to adjourn.
Happy Thanksgiving.
Seconded.
Happy
Seconded.
Thanksgiving,
All in
that's the
favor?
comment.
Aye.
Opposed?
Thank you for your service.
Thank you.
Thank you. Do you have an email?
Thanks, Paul G. Have a good night.
Let me give you the card.
Do you have copies, a copy of the exhibits that were given to you, because I'm trying to coordinate, we're trying to coordinate.
Yeah.
Okay.
Yeah, right.
Okay, this, oh, actually, that's from the other hearing. I believe this was new. This is an extra one.
think I have it.
You should.
Here you go. Oh, we have this one. We do have this one.